All right. So my name is Anna Hughes. I am the Director of Trusts with the Arc of Northern Virginia, overseeing the Special Needs Trust Department. And it is an absolute pleasure to introduce Claire Kelly. She works with Trust and Wealth, and she's going to be offering a estate planning for your family's future presentation today. This will be recorded and placed on our YouTube channel at a later time today. And so without further ado, Claire, it's an absolute pleasure to have you. Please feel free to take the stage.
Thank you so much for having me. Hi, everyone. My name is Claire Kelly. I'm so glad to be here with you today. I promise you're going to learn a ton. A little bit about me. I have 3 kids, 1 at Cooper and 2 at Great Falls Elementary. One of my children is special needs. And when we went through kind of some of the beginning stages, it was a really scary process for us. I felt very alone. I wasn't sure if he'd ever be able to live on his own. I wasn't sure what was going to happen to him after we passed. And I learned about special needs trusts and decided that I wanted to be able to help people do this. So I started a boutique law firm in Great Falls. I do general estate planning, but I have a particular affection for getting to work with families with special needs children. So this is what we're going to be going over today. For the next 30 minutes, I want to share with you all of the secrets of estate planning. There are a lot of misconceptions and confusion out there. So my goal with this webinar is to leave you with a better understanding of what can go wrong without estate planning, what documents you need, and how to get them in place, so you can make educated, informed decisions for what's best for you and your family. So these are the goals of estate planning, and they're pretty much things that you would think of. But for special needs families, there's yet another goal. Ensure continuity of care for my child and make sure they can continue to receive needed government benefits. And I'll give you a moment. I've been told never to read to literate people, so I won't be reading the slides to you, but I trust that you can take a look. Okay, so what's the risk to your family if you don't have a plan? And that's how I want you to think about this, because estate planning isn't really for you. It's about the people you leave behind. What is the risk to your loved ones if you get sick or pass away without getting your wishes in writing? Your family is going to be the one who has to clean up the mess, and it's going to be more expensive, time-consuming, and emotionally draining than it needs to be. When you have a special needs child, not having an estate plan could mean a lump sum inheritance that could disqualify them from needed government benefits, and your child may or may not be well situated to manage that amount of money. So, do you have an estate plan? Many of you are here today because you think you don't have an estate plan and you're interested. The truth is, you do have an estate plan. It's just that the state of Virginia has written it for you. In other words, there are default rules that kick in when someone dies without a will. You might not like the default rules, which is why we do estate planning. So you can override the default rules for your family and assets. And you can make these important decisions yourself instead of letting the state make them for you. So dying without a will or a trust is called dying intestate. And this may be the situation that many of you are in now. This is the doing nothing scenario, and it means you'll end up with Virginia's default estate plan. I will tell you right now, this is absolutely the easiest option short term. But there are downsides. These are the things that happen in Virginia if you die without a will, including the judge deciding who raises your minor children, your kids receiving the inheritance at 18 outright, and probate court being guaranteed. If you are okay with this default plan as I laid it out, you don't need to do anything. But I've yet to meet someone who actually wants anything on this list to happen, especially what happens in probate court, which we'll get to shortly. If you have minor children, one of your top priorities is getting in writing who you want raising your children should something happen to you and their other guardians, such as your spouse. In fact, I think parents of minors or special needs children need estate planning more than anyone, even more than the elderly, because there's nothing more important than making sure your kids are taken care of by the people you want, the way you want, no matter what. So at a minimum, parents should have a basic will, because by Virginia law, parents have the power to appoint guardians through a will. So what happens if you pass away and you haven't named guardians in a will? A judge is going to decide for you in a guardianship proceeding. And there are two types of guardianship of a minor. One, there's the guardian of the person, and this is who you traditionally think of, right? This is who they would live with. This is who would be raising them. And then there's guardian of the estate. This is who's going to be responsible for managing any assets left to the children. It can be the same person of the guardian as the guardian, but it doesn't have to be. So these are two important rules you want to think about if you have children below the age of 18. So the way to avoid all of this is simply to get a will in place and say in the will who you would want to take care of your kids if something happened to you. And you can do this as part of a trust package too. The point is you want to get it in writing rather than leaving it up to a judge. Another trick I'll say that I like to do is to have parents name standby guardians in a document outside of the will. Remember, a will is only effective at your death. So what happens if you're in a car accident or otherwise incapacitated and can't take care of your child? Oftentimes, Child Protective Services would get involved. But I like to help parents to name standby guardians so that not just in the event of your death, but in the event of your incapacity, we have documents giving permission to certain trusted adults to care for your children. I also prepare powers of attorney for these standby guardians, and I think that's really important because you want to make sure that they're actually able to take them to medical appointments, enroll them in school and activities, and try to keep their life as normal as possible during that sort of time. For guardians in general, you can name as many backups as you want, just in case your first choice is not available. I mentioned naming a guardian of the estate to manage the children's inheritance, and you will need to do this for a basic will, but we'll get to some better options than guardian of the estate when we talk about trusts. So first, let's talk about what is your estate. So we're going to talk about, and I'm going to use some cheesy props here, so forgive me. We're going to talk about your bank accounts, checking and savings, any sort of vehicles like cars, boats, motorcycles, planes, brokerage account. I have here a fake Google stock. We're going to talk about life insurance proceeds, which would, even though they're not paid out to you, this is actually part of your taxable estate. We're going to talk about your house or other real estate. My son painted this Encanto style. Let's see if I can make it show up. There we go. We're going to talk about any sort of retirement plans like 401ks. In addition to your home, maybe you own a vacation property, a beach property, and your very, very valuable artwork and things like that. My son made this too. Also, any business interests or intellectual property. So these are the things you need to decide, what do you want to have happen to all of these assets when you pass away? So what are your options in terms of your own estate plan? We've already talked about option one, letting the government decide. And for reasons that we've discussed, I don't know anyone who purposely chooses this plan. I will tell you, a lot of people end up with this plan, but nobody purposely chooses this plan. So you really have two options. You can do a will-based estate plan, or you can do a trust-based estate plan. This is a decision everyone has to make, whether you're married or single, have kids or don't have kids, regardless of how much money you have to decide if you want a will or trust. The majority of people today choose to do a trust instead of a will, but I want you to understand both options. There are many types of trusts out there, but we're only going to talk about two types today: revocable living trusts and special needs trusts. So let's look at a will. What does a will accomplish? Having a will is better than nothing. You get to name guardians for your minor kids. You can name beneficiaries for any asset held in your name alone. And you can name an executor, which in Virginia we call a personal representative. This is the person who's going to be in charge of wrapping up your affairs and estate when you are gone. So these are the things a will does, but it's all that a will can do. There are some pretty big downsides to just having a will. First, wills have to go through probate court at your death, and we'll talk about why this is bad in a few minutes. Your will, second, is only effective at your death. So it doesn't help at all if you're alive, but you're disabled or incapacitated and unable to manage your own affairs. Each state has their own law regarding wills. So a Virginia will may not be fully effective in California or Florida. So if you have a will-based plan and then move, you likely will need to redo your entire estate plan. Fourth, most parents don't want their kids to inherit everything when they turn 18, which is the age that you're legally entitled to inherit money. Most parents want their kids to get it later in life when they're more mature, or for parents with special needs children, they might want someone else to be managing it altogether. And finally, many assets are outside the reach of the will and often go unplanned for. Wills do not control retirement plans, annuities, insurance policies, and anything that's held jointly with someone else. So probate court is a specialized court that handles the legal process of settling the estate of a deceased person, ensuring assets are distributed according to their will or state law if there's no will, debts are settled, and any disputes are resolved. As I said before, when there's a will, there's probate. This means that if you die with a will, it must be probated. I should say with a will-based estate plan, it must be probated before your money can be distributed to your family. This is also true if you die without a will. Everything goes through probate. And while your court experience probably won't be as traumatizing as Colonel Jessup's, it won't be all that pleasant either, because court is never a very fun process. There are 3 downsides of probate court. It's expensive, it can take a long time, and it's a public process. First, let's talk about how expensive it is. There are various fees associated with probating a will. Probate taxes, court fees, lawyer fees, fiduciary fees, filing fees, and in Fairfax County, Virginia, they can eat up as much as 3 to 5% of the probate assets. These fees are going to reduce the amount of your hard-earned money that ultimately goes to your family. So we're going to use an example. Rebecca Wilson is a single mother. She has a will, and the will says that she wants all of her money to go to her daughter Amy when she passes away. These are Rebecca's assets. She has $800,000 of equity in her home. She has a savings account, brokerage account, a life insurance account, and a 401k account. The problem is Amy's currently 10 years old. And because Amy's a minor, things like life insurance and 401k that could normally pass by beneficiary, meaning they would normally go, or they could go outside of probate directly to a person, have to go through probate because they're going to a minor. And in addition to probate fees, the court is also going to be adding a special custodian, which will charge even more fees to manage these funds until Rebecca turns 18. And of course, when she turns 18, she then gets all of this outright, which may not be what Rebecca intended. So even using the conservative 3%, $142,500 is going to be lost to probate. And this is money that Rebecca probably would have preferred go to Amy. And this is all just a probate will that simply says she wants all of her assets to go to her daughter. So in my opinion, that's a bit crazy. So this is a pretty big downside to dying with a will that most people are totally unaware of. The costs of probating the will at death can be significant. There are other downsides to probate too. Probate is a public process. That means your will becomes public record when you pass away, and anyone can go look at it. They can see how much money you died with, who you left it to, and that's going to include the names of your minor children. Unfortunately, there are bad actors out there who hang around probate courts and try to take advantage of people who have just gotten large sums of money. Probate is complex enough that your family is going to want to hire a lawyer to help out. That's part of what makes it so expensive. And a judge has to approve everything every step of the way. Finally, it takes a long time. In Fairfax County, for example, it takes between 6 to 18 months. And during that time, most of your assets are frozen, which means they won't yet be distributed to your family. So you may be asking yourself, with all of these downsides, when is a will-based plan appropriate? I get asked this question all the time once people see the downsides of having a will. And the answer is that if you have a probate estate of less than $50,000 when you pass away, you're eligible for a simplified probate process in Virginia that is very easy and inexpensive. Additionally, if you anticipate litigation over the disposition of your estate, it may be a good idea to have certain assets pass via probate to ensure judicial oversight. Now, what I mean by this is not that you put all of your assets in a will, but if there is that one family heirloom ring that you think people are going to sue over, you could choose to put that in the will, just so that it has that level of judicial oversight. So let's look at your third option, and that's something called a revocable living trust. And again, this is the option that most clients prefer. I'm just repeating, there's a lot of different types of trust out there. So you might see this and say, well, I've heard about an irrevocable trust and I've heard about this, but we're going to focus today about revocable living trust for this part. So a trust is a legal instrument that holds your assets and lets you make rules for their disposition. A lot of people have trouble with the concept of a trust. And so today I'm going to use a little bit of a visual. But first, I just want to reiterate, a will is a substitute, or a trust is a substitute for a will-based plan, right? You're going to put into the trust where you want your assets to go. You'll name the beneficiaries. It's revocable. You can change it. You can amend it. You can do whatever you want, and you have total control during your lifetime. So a revocable trust is kind of like a kid's backpack. When your child starts school, they can pick out a backpack, and it can be any kind of backpack, any color, any size. There's a million options. Your trust is the same way. You set it up so it accomplishes what you want it to accomplish. The goal is to have your trust hold all your assets, because then those assets will be distributed according to the terms of your trust when you pass away. Anything that is inside the backpack bypasses probate. That's the really exciting part. So right now, assuming you don't have a trust, all of your assets are in your name. This is bad. That means they go through probate. What you want to do is move your assets into the trust. And the way that you do that is that you basically change the name on the title. I'll give an example in a minute. Again, everything in your trust will bypass probate and you still maintain complete control. So let's talk about how you fund your trust or fill this backpack. So there is, let's say again, this brokerage account. And right now the brokerage account is owned by Rebecca Wilson. Rebecca would fill out a form with her brokerage company, changing the title of the account from Rebecca Wilson to Rebecca Wilson as trustee of the Wilson Revocable Trust. And just like that, she has put it into her backpack. So you want all of your assets to be held in the name of your trust. In other words, you want all of your assets inside the trust or backpack. So your trust document, it's like the backpack. You set it up exactly how you want, and then you move all of your assets into the trust. This is called funding the trust. And then when you pass away, everything held by the trust goes to your family without any probate court involvement. So your awesome home, you're actually going to retitle that deed and re-record it in the name of the trust. And this is something I include with all of my trust packages. You are not able to retitle your 401k, but what you're going to do is change the beneficiary of your 401k to the trust. And then it goes in the trust. You're going to put any bank or savings accounts in the trust. You're going to change the beneficiary of your life insurance to trust. You're going to put your very, very precious valuables, which we're going to call tangible personal property, into the trust. And we do this for one big memo that says, everything that I own, my stuff, and any stuff that I acquire in the future is going to go into the trust. If you happen to own a beach place or a second home, that goes into the trust. Now, you'll notice something I did not put in the trust, and that was vehicles. That's because in Virginia, there are two very simple ways to transfer a vehicle at death without going through probate. And for liability reasons, it's better not to put it in the trust. So there's three roles in every trust. There's the grantor. That's the person who contributes to assets and creates the trust. There is the trustee, and that's the person who has full control over the trust assets and distributing them. And there's the beneficiary, and this is the person who is entitled to the assets. This is the person for whom these assets are meant to be spent. And during your lifetime, you hold all three roles. So let's look at Harry and Wendy. They've created a revocable living trust, and they occupy all three positions during their lifetime. They have total control. They're the grantors who set up the trust and transfer their assets. They're the trustees. They have make all decisions with the trust. And finally, they're also the beneficiaries of the trust who have the right to spend and use the trust assets any way they want. In other words, Harry and Wendy still have complete control over their assets, even though their assets are titled in the trust. What does it mean to be in total control? Well, it's business as usual for Harry and Wendy. They can amend their trust or even revoke it if they want. They have rights to manage the property, sell it, buy it, and their income tax forms are filed the way they've always been. Property taxes on their home get paid the same way. Because this is a revocable living trust, the government basically ignores it for tax purposes and continues to tax Harry and Wendy as individuals. So they do still owe taxes on anything in that revocable living trust, but they're just paying it on their 1040 or however they normally pay their taxes. So a trust solves all the problems that come with a will. You don't lose that money to probate court. Assets can go to your family in weeks, not years, and it's totally private during your life and at death. Also, trusts are domiciled where they're created. So you could have a trust domiciled in Virginia and an estate plan set in Virginia. And if you move, you wouldn't necessarily need to redo your trust. There's going to be some ancillary documents that you might need to redo, but you wouldn't need to necessarily redo your trust. I like to think of the revocable living trust like a multi-purpose tool. It can do just about anything. The most basic form of a revocable living trust is where you put all that stuff in the backpack because you want to avoid probate court, and then you die and it gets distributed. So I had a recent client who had 2 adult children, and she wanted to put everything in the trust just so that it would avoid probate. But after she passed, she wanted it to be divided into 2 separate shares, which we call descendants shares, and then given outright to her children. But there's unlimited options. You can have descendant separate trust, or you could have a special needs trust. According to Financial Planning Magazine, when clients were asked about the security of their wealth, their #1 concern was that someone would take financial advantage of their children or grandchildren. This is even more important when the parents are no longer alive or able to look out for them, or when you have a child who is susceptible to being taken advantage of. A trust can also help you keep all that money in the family. So remember, what we're talking about now is how you are going to design your backpack and what you want it to accomplish. And one of the things parents often want their trust to accomplish is they want to make sure that the money they leave their kids isn't spent unwisely or squandered or otherwise lost. Let's look at a couple of things that parents worry about when they're gone. They worry that they're going to leave their money to their children, who then commingle that money with a spouse, only to lose half of it in divorce. They worry their kids will lose their inheritance to creditors or lawsuits. Maybe one of your children is going to become a doctor and unfortunately is very prone to lawsuits. And importantly, for children receiving certain benefits, they also worry that the inheritance will disqualify those children from receiving the continued benefits. Now, Harry and Wendy have 2 awesome kids, Denise and Sam. They have a revocable living trust, but they've taken no steps to make sure that the wealth is not wasted once they're gone. That's because they have it currently set for outright payments, which only dumps a huge windfall on Denise and Sam. Harry and Wendy are leaving behind $2 million. In this case, Denise and Sam will each receive $1 million from Harry and Wendy, which represents a lifetime of hard-earned wealth. Denise is married to Jason. Jason isn't a very hard worker and doesn't do much to support the family. Denise gets her $1 million inheritance, dumps it into joint bank accounts with Jason, and when they get divorced 5 years later, Jason is entitled to half. This is the last thing Harry and Wendy wanted, to work hard all their lives only to see half of what they leave their daughter go to her ex-husband. Sam, on the other hand, is unmarried. He is disabled and living on his own, receiving both Medicaid and supplemental Social Security income, or SSI. What do you think happens when he gets a check for $1 million? First, he's going to lose his government benefits. You might say, that's not so bad, he has $1 million. But that million needs to last him for the rest of his life. Second, Sam is a very kind and trusting individual. A new friend offers to help him invest the million, and you can guess what happens next. So instead, Harry and Wendy consult an estate attorney and reassess their options. For Denise, they understand they can give it to her outright and the dangers that could come with that. They could do staggered, that's where you give a certain amount at 25, 35, etc. Or they can do something which is called a children's trust, which we're not going to focus on too much today. But a children's trust, you can think of like a tube of toothpaste. Anything inside the trust is protected from creditors, from spouses, etc. But money can be doled out and squeezed out when needed for Denise. But I'd like to focus on Sam today. For Sam, they want to give half of their life savings to Sam as well, but they don't want him to lose his benefits or being taken advantage of. So instead of giving this money directly to Sam, they're going to give his half directly into a special needs trust for Sam's benefit. So let's talk about a special needs trust. Because the assets went straight to the special needs trust, and Sam does not own the assets in the trust, he remains eligible for benefit programs that have asset limits. You're going to see here the trustee's job is to use the trust funds to improve the quality of Sam's life by supplementing his government benefits, but not replacing him. You'll notice I added an asterisk. Depending on the asset levels, there may be rare occasions where the trustee will decide it's better for the beneficiary to not receive government benefits. For example, if there was an insane amount of money in here and Sam likely had a lifespan of 5 more years, then they might not worry about government benefits. They might just worry on spending money and just doing whatever they can to make Sam happy, even if it messes up his government benefits. But that's not the case for most people, obviously. It would be impossible. So first, remember, the goal here is to enhance Sam's life without losing government benefits. It would be impossible to put together an exhaustive list of supplemental expenses that this money could be spent on. But here's a few examples. As you may have noticed in the earlier slide, Sam is a big fan of stand-up comedy like myself. And so for Sam, Wendy and Harry have set the trust up so it pays for Sam to go see a stand-up comedy show at least once a month. And it covers the specialized transportation to get him to and from the shows too. Given how social Sam is, Wendy and Harry also arrange for the Special Needs Trust to pay for a second ticket to each show so Sam can bring a friend. Though there are more limits to a special needs trust than other trusts, parents still have plenty of room to decide what they want to have covered. For example, there are parents with children who love baseball, and they want their special needs trust to ensure season tickets to Nationals games. So special needs trusts, we're going to talk about first party and third party. And if this gets confusing, please know that's because it is. Okay, so a first party trust is if the person who owns the money makes a trust for themselves. So for example, if Harry and Wendy had left that $1 million directly to Sam, Sam could set up a first party special needs trust and open his own special needs trust for himself. At the end of Sam's life, Medicaid is going to raid the trust and take back all the funds they spent on Sam. This usually leaves the trust practically empty. But then there's a third-party trust, and this is a family-funded trust, and it's treated differently. So in the example we were just talking about, where the funds go directly to a special needs trust, Sam never owned this money. It went from the parents' revocable living trust into this special needs trust, which Sam does not own. He's the beneficiary of, but he does not own. And so because he does not own this money, at the end of his life, there's no Medicaid clawback, which is really cool. And any remaining funds, Harry and Wendy can set it up so that they're left to Denise or to whoever Wendy and Harry desire. So there's also two different structures of trust. There's a standalone trust and a pooled trust. And a standalone trust is where the revocable living trust says, upon my death, in this case, half of the assets are put into a special needs trust that is hereby created, and it's going to be managed in this way. And they name a trustee, and there is somebody who's going to be in charge of investing that money. There is someone who's going to be in charge of making disbursements, of deciding when to do that. And it's just a standalone account. And it may or may not be managed by people who have experience with special needs. Then there's pooled special needs trusts, like the one that the ARC offers. And pooled special needs trusts are really cool. So what they do is they pool all of the investments from different people together. So, let's say there's a family who doesn't actually have enough to do a standalone trust because you need at least 500,000 to even make it worth the fees for standalone. And let's say there's also a family who has 2 million, but just knows that the ARC's trust is better. All of these funds get pooled together. So from an investment perspective, there is a reduction of fees, et cetera. Even though they're pooled together, they still all have their separate shares, and it's kept separate, of course. So I want to touch for a minute on the ARC of Northern Virginia's Pooled Special Needs Trust, because it's really cool. So the way that this works with the Pooled Special Needs Trust is that the trustee is, in this case, Key Bank. It's the bank that's investing the funds. The trust manager is the ARC itself. And then there's going to be a primary representative. And this is going to be the person who is going to work with your special needs child and help tell the trust manager, the ARC, and Key Bank, hey, listen, we need a disbursement for X, etc. The thing that I really appreciate about the ARC's pool trust is because all they do is focus on special needs individuals. They are more likely than a normal trust to notice if someone is being financially taken advantage of or not getting the care they need. Something special about the ARC's pool trust as opposed to others is they will actually accept real estate as well. Now, I say that with a giant caveat. I do not recommend that you put real estate into a special needs trust. I've had several parents who say, I've bought this townhome, and the idea is that when I die, my child's going to be able to live there, and that way they'll always have a place to live. Well, this person in particular who I spoke with, their child isn't actually able to live on their own. So that could be problematic. Also, owning property, there's all sorts of caveats, but it could or could not mess with certain benefits. So I encourage you to learn more about the ARC of Northern Virginia's Pooled Special Needs Trust. The first step I'd recommend is attending a Trust Talk Tuesday. They're every other week. They're awesome. Anna, or one of her great colleagues, leads them. I put on here the website, thearcofnovatrust.org/events. And so you'll be able to see there the next Trust Talk Tuesday and sign up for it. And I really encourage you to do that. So I want to take a quick moment to talk about estate taxes. Estate tax is due when someone passes away and their estate is above a certain dollar amount. So not everyone has to pay estate taxes, only people with a certain amount of assets. There are two estate taxes we need to think about, federal and state. Thankfully, Virginia does not have an estate tax. Yay us. The way to do the math is to add up the value of everything you own, and if it's more than these numbers, including things like life insurance, your estate may have to pay estate tax when you die. But right now, the estate tax threshold is $13.9 million a person, or about $28 million a couple. Over that, the rate's going to be about 40%. So there are very few people who need to pay estate taxes right now. However, just because people don't need you right now doesn't mean that's how it will always be. For example, that current 13.9 million expires at the end of this year, and it goes back to roughly $7 million a person. And the laws change all the time, even about what is included in your taxable estate. If you are someone where estate taxes might be a concern, you can avoid or minimize these taxes with advanced estate planning. Again, the laws change. You could have a taxable estate in the future, even if you don't today. Okay, so I've shared a lot with you, but knowledge is not enough. You need to take a step. Maybe that next step is attending a Trust Talk Tuesday. Maybe that next step is contacting an estate attorney. But whatever you do, you need to make sure that you take what you've just learned and don't say, oh gosh, that's great, I should do something. Many people avoid this because these are hard decisions and people don't want to think about these things. But this is a really important thing that you can do for your family. So think to yourself what you need to do, how you're going to make it happen, and how you're going to get started. Thank you for letting me speak with you all today. Does anyone have any questions?
So Claire, we have one right now in the Q&A, and it says, if you designate a beneficiary outside of a trust, does that go through probate? For example, designated beneficiaries for a brokerage account takes precedence over what is in a will. So why use a trust?
Okay, this is a really great question. Thank you for asking it, anonymous attendee. So in general, a beneficiary form trumps a will. However, many people have their beneficiary form set up so that their spouse is their beneficiary and their contingent beneficiaries are their children. So if you and your spouse die in a car accident and your children receive it and they're minors, it will go through probate, even though you had a beneficiary form. So if you die and your spouse does not die and it all goes to your spouse, that can absolutely work. Whether you want that all to be passing outside the trust is another story. One of the benefits of using a trust here is because you're able to take all of your assets and decide the distribution plan. So even if someone ends up being a minor when you pass away for this beneficiary form, you won't experience any sort of negative benefits. Also, many people want to divide things in a certain allocation. For example, after the spouse has passed, they want it to be equally between certain children. And if you were using a beneficiary form, that might not all work out that way. Additionally, I don't know if any of you all have heard of the Secure Act. It is very boring, no need to read it, but the final rules came out last summer, and it has to do with required minimum distributions from your retirement accounts. And if you have the trust listed, and if it qualifies as an accumulation or see-through trust, which in general, the revocable living trust and the way we do are set up that way, there can be some benefits, including for people with special needs children, that will actually expand the time period over which they would be able to use those funds. I see the next question is, what is the average cost of setting up? Oh, I'm sorry. Okay, there we go. What is the average cost of setting up a revocable living trust? Okay, this is the lawyer answer where I feel like every time I give that, I need to snap a rubber band. It depends. So there's generally two types of estate planning attorneys. There's estate planning attorneys who sell forms. And so they have software, they put your name in it, you answer some questions and they print it out. And those can be very inexpensive. Or there's the estate planning attorneys that craft a plan that's really specific to you and your situation. The last trust that I created, I spent 32 hours on. And this was a very, very complex trust. I don't want you to think that's how long it takes for all. I charge flat fees. I'm not able to answer the question as to an average cost. Me personally, I don't share my flat fees until we have gone through an estate strategy session, so we can talk about what type of planning is best for you. But then it is flat fees, and so there's no surprises. And of course, they include everything like powers of attorney, living wills, healthcare agents, funeral directives, moving your house into your trust, etc. Okay, and it says, you mentioned revocable trusts. Are there irrevocable trusts? If so, what's the difference between them? So a revocable trust, as we talked about, you put all these things in your backpack, but the backpack stays unzipped, okay? So you can take things in and out, you can move them, you can change the terms of the trust, anything. An irrevocable trust is a trust where once it's created, it's set. You can't change anything. And that can have some tax advantages. For many couples, it's not necessarily what I would recommend unless there's estate tax issues. However, a special needs trust is a type of an irrevocable trust. And so that is a great benefit because it's an irrevocable trust. And Sam, in this instance, does not have the right to those funds. Somebody has to approve their disbursement. It protects him and it keeps that money separate. Another time when I sometimes recommend an irrevocable trust is an irrevocable life insurance trust. So if you are someone who could potentially be subject to estate taxes in the future at a lower level or even lower than what it could be, it is a very easy process to take a term life insurance policy, retitle the ownership of it into this irrevocable life insurance trust. And then what happens is that actually passes outside your taxable estate, no longer part of your taxable estate, but will still benefit your beneficiaries in the same way. I hope that answers the question. Okay, I understand that once an S&T is funded, it is very difficult to make any changes. Is that true? Okay, there's gonna be another asterisk here. So, and actually I see that Anna are you putting a little note there that you want to answer this question?
I just marked it as answering it live, but
Oh, okay, sorry.
yeah,
So
no,
I
it's
was
okay.
just gonna say, generally, a special needs trust is not usually fully funded until the death of the parents. So, if you were to set up a standalone special needs trust, you wouldn't actually be funding it yet. You'd be creating the structure that would be funded after death. When you set up a pooled special needs trust, you have two options with the ARC. You can have it be unfunded, and then there's a minimal yearly cost for kind of keeping it up and active, or you can deposit $500 in it. And that kind of has it be funded in existence. In terms of whether you can make changes, so it depends. It depends on who your lawyer is and how they set it up. So I have mine set up so that the trustee has the power to make certain changes, either for tax benefits or for eligibility and benefits, if that makes sense. So there's a very limited ability that I write in for it to be altered in certain minor ways. And they're really more of ways that are, okay, and there's a new law passed, we want to make sure we're still in compliance with the law. And so there is the ability to make certain very small changes. As for making changes to the pool trust, I'm going to actually pass that over to Anna.
So with pooled trust, it's similar, where there can be minor changes made, but there are certain things within the agreement, the joinder agreement, that would not be able to be amended. So grantors, you can't change who set up the trust in the first place. You can't change the beneficiary of who's receiving, the benefit of the trust. But there are other smaller components that we can amend, such as primary representatives or remainder beneficiaries. Now, I do want to put a nice little asterisk there and share that the only persons that are granted the authority to request the amendment are the grantors themselves. And so if there were changes that needed to be made, I would say get in touch with our team, and we can review the trust agreement and figure out what we do have the ability to change. Now, I will say you can't revoke an irrevocable special needs trust.
Right.
So that's just something to keep in mind.
So one thing I would add to that, Anna, though, is so let's say parents come to see you and they set up the trust for the pooled special needs trust. They talk to their estate attorney. They give them the exact wording here. I work with you so that the funds are going to go to that special needs trust, but they fund it with $500. They can absolutely change that. If they don't mind losing that 500, they could say, thanks, we're doing another one now. We're going to do something totally different. And then we would just change it in the trust where it goes to. So, funded can mean two different things. It can mean that initial $500 funding, or you can mean after the parents have passed and it's fully funded. Once it's fully funded, it's much harder to change than when there's a token amount in it. I see the next question is, can one determine where the funds in a special needs trust go when the special needs individual dies? Absolutely. That's the joy of a third party or family funded trust versus a first party. With a first party trust, you can decide where they go, but that's after Medicaid clawback. There's really not going to be much left. With a third-party trust, you get to decide. You can set it up. So maybe your special needs child has children themselves and you want it to pass on to their descendants. Maybe they're not going to be having children and you want it to go back to their other siblings when they pass. You can design this however you want. This is part of the fun thing of designing your backpack. And this is true for both a standalone and a pooled special needs trust. And I just want to say, I have had some very high net worth clients who could absolutely afford a standalone, but who I still recommend a pooled trust for. And again, there's 4 different investment options with KeyBank, and so there are fewer investment options than what you would have with a standalone. But most parents looking to set up a special needs trust, their concern isn't how can I make sure that I get the absolute best growth rate possible. It's how can I make sure my child's taken care of. And that's a place where I really feel like the Arc of Northern Virginia shines. So it's something I really recommend regardless of income level.
The other thing I was just gonna plug in, Claire, you made a comment about the Medicaid clawback, and so I just wanted to highlight with a pooled special needs trust, you often have the ability to leave the remaining balance to the pooled special needs trust managing the account in lieu of the Medicaid payback. So you
Right,
have
so
a
if
little
you're a
bit more
first party,
choice. Yeah,
that's
first
so
parties
if
only.
you're a first party and basically everything's going to be gone after you die, and Anna, maybe you even have some information on the average amount that's left in one of these. You have 3 options. Okay, you can number 1 have Medicaid clawback. So I guess really 2 Medicaid clawback, and whatever's left, you can absolutely assign to a sibling or whomever you like. But it may be a negative balance, basically, meaning it may be nothing. Number 2, you can actually say, I'd like this to go to a charity. I'd like this to go to the ARC's pooled trust. And when that happens, and this is really, really cool, Medicaid doesn't do clawback. You actually get to take that entire amount that's left and have it support the ARC. I'm not sure why they passed that law because it certainly does not help Medicaid's budget, but I'm glad they did. Um, Anna, do you have any information offhand on about what's left in most first party trusts at the end?
I can't give a specific number, but what I always tell families is to stop and consider every Medicaid service that their loved one is receiving. And then, in the state of Virginia, you can actually look up rates that are paid to providers for services. My background is actually working in residential services. And so I know anyone with the DD Medicaid waiver, if you're residing in a residential program, the program can bill up to 344 days of the year. And if you look at the rate and you just do the quick math to it,
Right.
it's usually, I'm thinking on the conservative side, we're looking at $100,000 just for 1 year living in a residential program. And so that's really what I would push back is try to figure out what's that calculation and is there going to be something left?
And again, this is only for a first party trust. So if parents have done it right and they've set up their estate plan and they have it go straight to a standalone trust, your third party, all that cash is still going to be there at the end that hasn't been used for your child. But for first party, many people say, oh, I don't want to leave it at charity. I want it to go to the sibling or whatever, not realizing how little there may be left. So if you're doing a first party trust, that's certainly something to discuss with your estate planning attorney or with Anna if you like, about how you want to have that set up.
And I'm just gonna plug in just because first party is, I always say, first party is often what the attorneys are going to be referring to when they're talking about that type of special needs trust. The Arc of Northern Virginia calls it a self-funded trust. They're interchangeable.
So yes, okay. So the attorney term, and then let's use the real term. Self-funded, that's the first party, and third party is the family funded. So we'll all from here on out refer to them as self-funded and family funded.
Totally fine. Thanks, Claire.
I see we have another question. Many government benefits expired for a disabled person who marries. Does an S&T expire upon marriage? No, it does not. Okay, once an S&T has been established, what needs to be done if the family moves to a different state? Usually nothing. Now, there are some very rare situations where there are certain states whose special needs trust rules differ. And you do end up needing to move the special needs trust, which even though it's an irrevocable trust, that is built into it and that's possible. Anna, do you have an example you can share here?
I do. So what I always go back to is the Arc of Northern Virginia, for example, were approved by Medicaid in Virginia, Maryland, and DC. And so if someone were to move to a state where their Medicaid reviews our master trust agreement and joinder agreement and say it just doesn't meet the criteria of what they're looking for a special needs trust, that's where we look at having to move it over to a new program or a new trust. But it's more so dependent on Medicaid. It's not Social Security that would require you to move the trust. It's truly the Medicaid eligibility.
And so just to be clear, you're not saying that outside of DC, Maryland, and Virginia will definitely need a new one. You're saying that it meets those criteria, and for many other states, it also meets their criteria. But every state has their own. And if you end up in a state where they say this doesn't pass muster for you being able to continue to receive Medicaid, then both the standalone trusts that, or at least the type that I would draft, and the pooled special needs trust has that option to move its location. So for the pooled special needs trust, that might actually mean leaving the Arc of Northern Virginia and going to a pooled special needs charity trust in Indiana or wherever.
Right. Thanks, Claire.
Okay, so we have 6 minutes left. And I have a hard time believing that nobody else has any questions. This is one of those ask me anything times. Is there anyone with a hand raised, Anna?
There is not. I'm just thinking of one right now, actually, and this is
Sure.
a fun one. So I know we talked a lot about revocable living trusts.
Yes.
Are there other names for some, like similar to the self-funded being the same as a first party?
Yes.
Are there other names for a revocable living trust?
There are. Some people just call them a living trust. So, or a revocable trust, or an RLT, or a lifetime trust. So there's a lot of different names that people use. Often it's the living trust. I tend to prefer to refer to it as a revocable living trust because I also, of course, help families with living wills, and we don't want those two to get confused. But yes, it's a revocable living trust can also be called a living trust and many other terms. So I will take this opportunity, if nobody has questions, to talk a little bit about the ancillary documents that you also are going to want, right? So in addition to having this revocable living trust, and I'm going to, I'll go ahead and do this, and then I said we've got another question. You want powers of attorney for both parents, right? So that if something happens to you, you are able to have someone who keeps things running. The great thing about a revocable living trust or lifetime trust is that you don't have to wait till you're dead to use it. So your successor trustee, if you are incapacitated, can step in and make sure that your mortgage is being paid, that your kids' tuition bills are being paid, et cetera. So a trust can be used before you die. The powers of attorney, we do durable powers of attorney, meaning even if you're incapacitated, they stay active. We do healthcare agents, living trusts, and HIPAA as well. HIPAA, basically, you've probably seen those every time you've gone to any doctor's office. But let's say that you decide that if you were in a serious accident, you would want your brother to be allowed to call the hospital and find out how you're doing. We have your brother on there. I also do funeral directives, and then also, again, the redeeding of a house. Okay, but we have some questions, so I'm gonna move over to this. If you have more than one child and only one is disabled, then an S&T and a will are a good idea, right? If you have more than one child, only one is disabled, a trust and an S&T is a good idea. So again, remember, if you do any sort of will, you're still going through probate and you don't want that. So like the Denise and Sam example, right? You would have half of the revocable living trust go to Denise, and that can be through a variety of estate planning vehicles, through another trust, et cetera. And then you would have half go straight to the special needs trust for Sam. I hope that answers your question. I will say, speaking of ancillary documents, as much as you might feel like, oh, wills are awful. Even when I do a trust, I do something called a pour over will. And all that is a document that says, if I accidentally own something outside the trust, please put it in my trust. And unfortunately, you'll pay probate on that. So if the day before you die, you're walking down the street and you see a home for sale and you say, I'm buying that, and you go write them a check and you put it in your own name because you forget to put it in the trust name, the pour over will make sure that it eventually goes to the trust and is distributed according to your wishes. But it's hopefully you don't ever need the pour over will. Okay, why not put more of your funds into the special needs trust before you die? You could if you wanted to, unless you have a particular concern about creditors or liability. So, for example, let's say that you're a doctor and you're in a field that gets a lot of lawsuits. Instead of more fully funding the S&T first, I think if I were your attorney, I would talk to you about some credit shelter options that you might want to consider for your funds. Obviously, once you put something in S&T, that's not something that you can take out. So if the concern is that those funds will be dissipated against your will, there are other estate planning vehicles that we can talk about. If you want to go ahead and put more in the S&T, that's fine. For example, 500 is the minimum to fund one with the ARC, but that lasts about 30 to 32 years given the fees. I recommend if I'm going to have a client do a pooled special needs trust with the ARC, just put in $1,000. That way you don't have to worry about this expiring or becoming undone. I hope that answers your question. If the S&T beneficiary moves to another state after it's fully funded upon the death of the grantor, how difficult is it to have the S&T move to another state? Again, it's not difficult. This is written into the terms. So first of all, they might not need it to be moved to another state. So in most cases, they do not need the S&T to be moved to another state. If they do, because of specific Medicaid laws and requirements in that state, it's relatively easy to do, whether it's a standalone or a pooled special needs trust. If that's the last question, I will just close with, please do something after this presentation. Go to a Trust Talk Tuesday, contact an estate attorney. Please make sure that you take a next step. And another question, sorry, if the S&T is listed as the beneficiary on your 401k or IRA, then you do not need that included in the revocable living trust. Is that correct? Would you then need to be directed in a will instead? Just want to clarify. Okay, so this is really important. An individual who qualifies as disabled, instead of the 10-year payout for an IRA or 401k that most people have, the IRS will actually calculate the payout schedule based on their lifetime expectancy. And if you're doing that through a trust, though, it has to meet certain requirements. So the revocable living trust definitely meets those requirements to be an accumulation or see-through trust. For the special needs trust, it depends on that individual trust and how it is worded. So I would recommend you have it going to the revocable living trust, and then that things will get split and put into the S&T. If you're going to have it go to an S&T directly, that's something you want to make sure you speak with your estate attorney about to make sure that that S&T specifically with that language qualifies as a proper accumulation or see-through trust such that the disabled individual will get all those tax benefits. Is there ever a benefit to having a standalone S&T as well as participate in a pooled trust? I cannot think of a time when that would be beneficial. Anna, can you?
I can't. I could give you the only thought I had, which is a standalone trust, you're appointing your own trustee. Whereas if you're working with the pooled trust, you're trusting the pooled trust to select the trustee. And so there might be a world in which a family wants a certain portion of that estate to be managed by this trustee that I've appointed, and then the other one being tapped by the ARC. Or whatever the pooled trust is. That's the only thing I could see is more control under the trustee that you've appointed through your standalone.
The issue there, though, is that your child still has needs, and deciding where to pull those funds from and the availability of funds in different places can get very complicated for your personal representative or trustee. So that's really just not something I would ever recommend.
I'll echo it. That's just the only thing I can think of as why someone
Yeah.
would want to do that, but I don't see the true benefit to having both.
And if I could just make another plug, I would love to meet with any of you, but many of you may already have an estate planning attorney. And when you talk to your estate planning attorney about special needs trusts, just keep in mind there is a financial advantage to the attorney to doing a standalone trust, as opposed to referring out to a pooled trust. So if your attorney recommends a standalone trust, just make sure you ask a lot of questions. I'm sure they have your best interest at heart and they have a reason for it, but ask questions because there's really a lot of benefits to a pooled trust. And so it's something you want to make sure that you explore all your options.
Right. Well, we're coming up at 12:03, so I'm going to say we're going to call it for now. But thank you all for participating, and especially Claire, thank you for taking the time today to share the information with the families that have joined.
My pleasure. Thank you. Have a great day.
Take care, everyone.